David Villarreal was on trial for murder when his direct testimony was interrupted by a 24-hour overnight recess. Before the break, the trial judge issued a qualified conferral order. He prohibited Villarreal's defense attorneys from managing their client's testimony before he returned to the stand. The judge clarified that this wasn't a total ban on communication. Villarreal could still talk to his lawyers about sentencing issues or general factual information crucial to tactical decisions. This order created a direct collision between a criminal defendant's Sixth Amendment right to counsel and the court's truth-seeking mandate to prevent witness coaching through sequestration. The Supreme Court unanimously upheld the trial judge's order, rejecting Villarreal's appeal. But while the justices agreed on the outcome, they fractured over the underlying legal mechanics and how the law should define protected speech. Three distinct jurisprudential philosophies emerged: Justice Jackson's content-based majority rule, Justice Alito's focus on witness status, and Justice Thomas's strict textual reading of precedent. The court is reevaluating how it measures the boundaries of attorney-client privilege during a trial, shifting the focus from the hands of the clock to the specific substance of the conversation. Understanding this fracture is essential for practitioners. These nuanced differences now dictate exactly where litigators can draw the line between protected strategic advice and unconstitutional coaching. This case was built on two aging precedents. The first was the 1976 Getters ruling, which governed overnight recesses. In Getters, the court struck down a total ban on overnight communication, ruling that a defendant must be allowed to discuss broader trial strategy and matters unrelated to their direct testimony. The second was the 1989 Perry ruling, which shifted the focus to brief, 15-minute daytime recesses. Perry upheld a total ban during short breaks, establishing that brief pauses inevitably center on unconstitutional testimony manipulation. This created a misconception among lower appellate courts that any overnight restriction automatically violates the Sixth Amendment. The Villarreal ruling was designed to replace this strict temporal binary with a rule focused on the content of the conversation. Justice Jackson's majority opinion officially replaces the temporal framework with a substantive, content-based rule. This matrix maps Jackson's baseline. When a defendant takes the stand, discussion of testimony qua testimony sheds its constitutional protection. This unprotected zone prohibits chameleonitic adjustments to alter cross-examination. However, Jackson introduced a vital carve-out for incidental discussion. For example, if advising a client on whether to take a plea requires discussing the impact of their ongoing testimony, that specific communication remains protected. This rule changes trial defense strategy. Attorneys must now categorize the intent and content of their mid-trial conversations, rather than relying on the safety of an overnight break. Justice Alito's concurrence focused on the historical limitations of a defendant's right to testify. Alito argued that because early American courts deemed defendants incompetent witnesses, the act of taking the stand changes a defendant's legal status to that of a witness, triggering strict anti-coaching protocols. He warned that Jackson's incidental exception could be exploited as a loophole for illicit coaching disguised as strategy. Alito contrasts two scenarios. Advising a client to seek a deal based on general trial chances is permitted, but demanding a deal unless the defendant fixes mistakes A, B, and C on the stand is prohibited. His framework requires trial judges to act as gatekeepers, ensuring the strategy label is not used as a Trojan horse for testimony manipulation. Justice Thomas, joined by Justice Gorsuch, rejected Jackson's incidental framework entirely. Thomas applied a strict reading of the Perry precedent, asserting that a defendant has no constitutional right to discuss ongoing testimony, regardless of the context. He argued that creating a right to incidental discussion is a legal fiction that needlessly expands precedent and finds no basis in the text of the Sixth Amendment. For Thomas, the trial judge's order was constitutional simply because it allowed discussion of non-testimony matters. He saw no need for a complex balancing test. His view exposes a deep fault line over how strictly historical precedent should limit the practical realities of criminal defense. The final result of Villarreal is that the temporal bright-line test is permanently dead. Lower appellate courts can no longer automatically strike down overnight conferral bans based merely on the length of the recess. Trial lawyers must now navigate qualified conferral orders that explicitly ban testimony management overnight. Footnote 5 of the majority opinion contains a direct warning. We trust that defense counsel will not evade the spirit by couching discussion of testimony, qua testimony, in strategic terms. Attorneys must now rigorously self-police their mid-trial advice or risk severe constitutional and ethical violations. The court has established a fragile line between protected strategic advice and unconstitutional testimony coaching. Attempting to frame a chameleonic adjustment to testimony as tactical strategy will fail under the scrutiny of all three justices' frameworks. Villarreal preserves the central truth-seeking function of the trial without destroying the collaborative relationship between attorney and client. In the modern courtroom, the clock no longer dictates the boundaries of the Sixth Amendment right to counsel. The specific content of the conversation